Good afternoon. I realize this is the end of the day. My name is Rika Quintua, and before I get started, I sort of want to know how many of you are OCS staff? All right, good. And CASA staff? Okay, are there any attorneys? Very good, very good. Today we're going to talk about practical professionalism, and I'd like to sort of give you a little bit about me, a little background, so that you'll understand where I'm coming from. I'm an OCS regional attorney, and I've been with the agency 4 years. Prior to that, I was a defense attorney for parents, and I represented children for 12 years. So I have had sort of both sides of the table, so to speak. I've also been qualified as Judge Pro Tem, so I've had the opportunity to sit on the bench and sort of get an understanding of what judges are looking for when they have to make decisions on children's lives. This afternoon, we're going to talk about practical professionalism, techniques for assisting clients through the turbulent waters of the SYNC process, the Child in Need of Care process. Now, before I begin with that, I want to put you in the shoes of a family that's about to go through this in need of care process. When I meet a family, generally what I will see are people who are terrified. They have absolutely no idea what is about to happen to them. It is humiliating to go through this process. It's also embarrassing to know that a problem that I thought was my own is now known by everyone, because now the school knows that my children are not at home, and my neighbors now know that my children are not at home, and my family now knows that I have something going on in my life that I have chosen not to share, but now I have no choice. So that by the time you come in as the social worker, as the CASA worker, even myself as an attorney, be it for the state or for the agency, imagine what you're going to see. Imagine the disposition of a person who feels that, again, my most precious possession, my most precious gift is now gone, and not only that, there is absolutely nothing I can do. What we find are parents who would like to do whatever's necessary, by any means necessary. They are angry. They are disappointed. And if you are a case manager and you're not prepared for that, it's very easy to take that situation personally. It really has nothing to do with you. It has nothing to do with me as a defense attorney. But my job as an advocate is to make sure that that parent understands that we can walk through this process together, that we are partners in this process together, that these other players are also partners in this process together. However, there are some rules that we need to follow in order to get your children home. So with that understanding, we're going to look at disproportionality, and our introduction. Research reflects distinct points in the in need of care process where disparities exist, adversely affecting outcomes for children and families. The Louisiana Rules of Professional Conduct focuses on our responsibilities to our clients. Now, I'm talking about attorneys, but in my talk, I think you're going to find that I will touch on the responsibilities of CASA, the responsibilities of agency staff also. Attorneys and other legal professionals can be extremely effective in alleviating injustice when these principles are routinely and uniformly applied. That means it doesn't matter who the client is, they know they're going to get the same level of service every time, and we know that's what's going to be delivered every time. It's going to be an individual effort and an intentional effort on the part of the professional to make sure that each client receives the same level of service. And as a result of that, we create informed, empowered clients, and we hope that will help create better outcomes for children and families. Now, Our challenge. According to a 2008 Children and Family Research Study, in Illinois, the point of entry into foster care is the point at which the greatest disparity exists. So the point at which the children actually come into care. So let's talk about what that looks like practically, our everyday practice. For some of us, especially those who are in the agency, it means that we take just a little more time when we are thinking about dividing or separating, let's say, a white family. And let me back up a little bit and say, when we talk about African American children and poor white families and Latino families and other ethnic groups, I see the experience is pretty much similar. It's pretty similar. But when you see families of means, families of people who have access to resources, there tends to be a little more time involved before there's an actual division, an actual separation of those children from the home. That means that they will have an opportunity to receive preventative services. There will be more of a reason to refer them to family services. Or let's look at AR. Let's look at other alternatives. So that's a practical way of looking at it. And that's not to say that there's something definitely wrong or someone is doing something absolutely wrong. It's just a matter of fact. On the flip side of that, we also see attorneys who render ineffective assistance of counsel. We have attorneys who come to court, and because they are part of a big firm, they will do their other work during termination proceedings. They will do the work that they are being paid for in the big firm, even while they are handling termination of parental rights proceedings, and they are representing the child. We see that kind of thing. So we want to make sure that if everyone is receiving our very best service all of the time, then we will have better outcomes. However, back to our challenge, the point of entry into foster care is the point at which the greatest disparity exists. The report further indicates that the greatest amount of disparity is in the likelihood that an African American child will be investigated for maltreatment, and once in the system, African American children were less likely to exit to permanence. Let me say this, the in need of care process has a beginning, and we need to get used to the fact that it has an end, that is a story, that there is no languishing in care, that there has to be a plan for exit, just like there is a plan for entry. And that's for all children. Now, with that challenge in mind, for our rules of professional conduct, we will look at these particular rules: competence, scope of representation, diligence, communication, confidentiality of information. And a lot of those rules were covered by Judge Brown. I'll do so a little more in depth just because it's important for attorneys to understand that they have a responsibility to their client to provide excellent service to every client. Now, Rule 1.1, competence. I'd like to highlight that a lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. Now, what that looks like is this. If you are practicing in juvenile court, a lawyer should know the children's code. They should know in need of care law. It is presumed they would know, but we have attorneys who come in who do not know. And because they are able to ask, they are able to get through the trial without any problems with the court. However, in order to render the best representation, it's best to know the children's code. Attorneys representing children are required to exhibit a certain level of skill. The law now requires children's advocates to have a minimum number of CLE units every year to enhance their own knowledge base to properly represent children in the in need of care process. And we have changed our process this past year, East Baton Rouge Parish. I am from Baton Rouge and I do practice in Baton Rouge by having appointed advocates. And I realize that's not so in every part of the state, but these attorneys are especially dedicated to children now. Our public defenders have certain attorneys that they are now devoted to representing parents. Major federal legislation. Attorneys should also be familiar with the federal legislation that affects child welfare law. Here we have CAPTA, the Child Abuse and Prevention Act, ICWA, Indian Child Welfare Act, and this legislation may not be used in every case. However, it does affect our state law and does affect our state streams of income. Preparation and thoroughness. Do your homework. If you are an attorney, and that would be a defense attorney, a children's attorney, it's best to become familiar with the agency's policies. Not only that, become involved with the programs that they have where they invite stakeholders in to talk to them about how their policy works and what would work better for your clients. Here we would look specifically at the alternative response units and the family service units. These are units that are devoted to family preservation and to keeping families from more restrictive courses of action, from having children removed from the home. If you are an attorney, ask why your family was not referred to one of these units. There needs to be a safety and health issue or an imminent risk issue involved, but otherwise, if that family can be maintained, considering the fact that disproportionate numbers of African American children come into the system, it is worth the while of the attorney to investigate these diversionary systems put in place by the state. The second thing I have here is contact the investigator. Upon receipt of the appointment, contact the child protection investigator. We all are familiar with the continued custody hearings, and it's important, as Judge Brown talked about, to not speak to your client immediately before they walk into the door of the courtroom. Once you receive the appointment, it's incumbent upon the attorney to do his own homework, to contact the investigator, to get a copy of the affidavit, to read the allegations, to review that particular verified complaint with the client. That means I don't assume that the client can read. I sit down and read. This is what they're saying about you. You tell me your side of the story. It's important that that client begins to understand what is involved, how I can, what's involved with this process, and what do I need to do? What witnesses need to appear at this 72-hour hearing or this continued custody hearing to help me establish my case? The client is your partner, and that client has a right to participate in his own representation. Where are the children placed? Where are the children? It's amazing how many clients do not know. They know they're in a foster home. They know they're going to see them in 3 days. Can you imagine how you would feel if someone told you you could not see your child for 3 days? It's amazing. We need to determine where that child is placed. Is that child in a least restrictive placement? Is that child with a relative? And most importantly, and this is for our staff, our OCS staff, when you appear at a continued custody hearing, make sure you have done your homework and uncovered the relatives, because they do show up at that continued custody hearing. They know everything, and they will tell you, you didn't call me, you didn't ask me about taking this child, and I am prepared. And that also refutes reasonable efforts to eliminate removal from that home. It builds your case, so it doesn't take anything away from the worker, but it is a requirement. Also, I would continue to encourage the judges to be gatekeepers for reasonable efforts findings, to require evidence that the agency made all the efforts necessary to keep that child in the home. It's just that important. Have the parents been properly notified of the time and date of the hearing? How many times have I heard, I told them yesterday, I told them we would have the hearing tomorrow? Well, due process requires that we have notice and written notice and notification of the hearing date. Well, okay, let's see what we can do. Can we get that client transportation to the court? Are we sure that the client has a way to get to that continued custody hearing? And what it does is it prevents a continuance. It prevents a delay in the proceedings if these things are done preliminarily. Now let's look at skill, another aspect of competence. Our ability, our talent, our expertise. We reviewed the affidavit with the client. We are interviewing the client and interview the witnesses. We have searched for relative placement alternatives. We have assured reasonable efforts have been made to prevent or eliminate removal. Have pertinent witnesses been subpoenaed? That means your doctors, your police officers, those persons who are going to establish your case. It's important for not only the workers to build their own case, but have the attorney in a position to cross-examine each of those witnesses who are making allegations about their client. It's absolutely necessary that that client have a full continued custody hearing, a fair continued custody hearing. They are entitled to such to protect this fundamental right to parent. We prefer to think of the participants in juvenile court as partners, and in this particular presentation, we think of it as a strong crew. The first and most important person in your crew is the actual client. The client needs to understand each portion of the in need of care process. That means that we will explain to them each hearing. What's going to happen? What are they going to see? If this is not successful, what hearing will occur next? And to do this at every successive hearing. That means that if my client has a disability, if I explain to that client, or if an attorney explains to that client what is going to happen, even if they forget, they will remember that I told them there would be a next hearing. That this is not the hearing on the merits. This is very similar to a probable cause hearing. We want to protect your child. This is what will occur at the appearance hearing. This is what will occur at the adjudication. This is what will occur at the disposition. Hopefully, the child will be home prior to that point, but if not, this is what will happen. This empowers the client to work his own case, so that if they understand that, all right, this is going to go on for a while, I need to work with the case manager. I need to determine what I need to do to get my children back. That also means that they will understand that there will be a family team conference, that they are to participate fully in the family team conference, and that the advocate will be there to make sure that they are completely engaged, that what they don't understand, that advocate will understand, and they will make sure that in the family team conference it is discussed. We encourage trust. The best way to get a client's trust, a client to trust you, is to be very honest, to explain to them what they're about to experience, to maintain their confidentiality, and to explain to them their chances of success, and to explain to them also, as the judge referred to, in your experience, what chances the client has at that particular time for being successful in his case. If the client has to have parenting classes, or if the client has to have a psychological evaluation, or if the client has to have a job or a home, to explain to them, these are the things, these are the barriers to return for your child, to make sure that they understand that. And if they can trust the advocate or the attorney, then by the time they get to the case manager, it's a lot easier because they've heard it before and they're not as defensive. And if they are, to give that particular client the opportunity to call the attorney when they have questions, to know that I'm in a position where I don't understand what's going on. Call me. Call the attorney to get the information that you need. Use the education on the in-need care process to assist the client with the appropriate responses. It helps diffuse the anger. Education will help the client maneuver through the process. Attorneys should build relationships with other sync attorneys, with other in-need care attorneys, to build a relationship with the court. How do you build a relationship with the court? Becoming credible in the eyes of the court, giving truthful information, doing your own legal research, taking advantage of the discovery process to learn your case. This is also true for OCS workers. If you want to build credibility with the court, understand that when that judge sees the case, he is holding the life of a child in his hands. And so if you give them the information that they need to make an informed decision, you are building credibility. But if the court report has stale information, or if the court report has information that is incorrect, that does not encourage credibility. I'll give you an example of that. Had a case recently where there was an incorrect birth date on a court report. Just an incorrect birth date. But if you read the court report, you would see that there was something incredibly wrong if a 10-year-old child could sell drugs. He sold crack, he smoked marijuana, he ran away from home, he robbed someone, all this, and he was 10 years old, and he was on runaway. Nobody knew where he was. And so when I knew what this triggered in my mind, my question was, my goodness, all of this and the child is 10? Well, of course, it did the same thing to the judge. The judge said, I can't believe this child is 10 and all of this is happening. Well, the child was actually 15, but by that point, by that time, the judge's ears were up and antenna were up and we're ready to get on the worker. And it's all because of, just small things, accuracies in your reports. This assertion that the father's whereabouts are unknown. And we see that quite a bit. And the judge turns to the child and says, little Johnny, where's your dad? And he said, well, he's on 39th Street in the White House. Well, that interferes with the credibility of the worker. So all of those things are important. You're building a relationship with the court. Building a working relationship with the case manager is so important for an attorney. It makes your life so much easier because they get the information first. And if you can understand what's going on with your client before the hearing, to have a relationship with the case manager so that the services that you are requesting, you can call and ask about. Just a friendly call. The referral to the psychologist, has that been done? Versus the assault on the stand when time is passing. Time is passing because now it requires another delay so that we can get that information from the psychologist. So it's really important for attorneys to build a relationship with the workers, with the case manager. It's important for an attorney, and this is not just for the attorney. It is for every CASA, for every participant who is allowed to attend the first family team conference. I can't overemphasize this point. And that is because that is where the case is formed. It is the foundation upon which all of the decisions will be made up to termination. And so if everybody is at the table at that particular conference, I think you will find that the input that the parent can have, the input that the family can have, the input that the attorney has will affect and positively affect the parent. It will positively affect the family. And that also is true for the children's attorney to be there. And it's easy to not be available for those conferences, but I want to encourage you to make sure that if you can't attend any of the other subsequent conferences, that you will be at the first conference. Also, to work with CASA. I usually read my court reports and my CASA reports together. I want to understand what the CASA sees. I want to understand what our agency sees. It's great to build a relationship so that you can call and ask, has this visitation occurred? Has this service been received by the client? How are the visits going between the parent and the child? Now, I say that, but many of the families have a problem with intrusiveness on the part of CASAs. They understand why the state has to be involved. They do not understand why a CASA has to be involved, especially if the CASA seems to be intrusive. That means I ask you things that are extremely personal, that really aren't relevant to the child's health and safety. I open your refrigerator. I go to the foster parent's home and I didn't make an appointment. I am not working with the foster parent very well. And I find that CASAs have friction with foster parents and with parents because of things like that. Now, as an advocate, I would closely monitor the relationships between CASA and my clients, because sometimes they didn't necessarily work in the client's best interest. However, the CASA's information and insight are invaluable in exploring the life of a child and the best interests of that child. Tackling storms. There are storms in the need of care cases. Rule 1.2, the scope of representation and allocation of authority between the client and lawyer. What I want to emphasize is a highlighted portion. A lawyer shall abide by a client's decisions concerning the objectives of representation, and as required by Rule 1.4, shall consult with the client as to the means by which they are to be pursued. A lawyer may take such action on behalf of the client as impliedly authorized to carry out the representation. It is easy to believe that we know what is best, but that is not our role. Our role is to represent the views of the client, to represent not the interests, but the views of the client and what it is that they desire. We find that especially in children's cases, and we had a situation just recently where an attorney felt very strongly that the parents in his case could not parent, and the children desperately wanted to go home, and the parents had complied with the agency's requirements. And as a result, he delayed the case for over a year. It was an uncomfortable situation for all involved. And then the attorney excused himself. He took another position and left the case. And as soon as he left, the family was reunited. It is the attorney's role to abide by the client's decisions. And that includes a child, and then the judge makes the final decision, what's truly in the best interest of the family. We have high waves in our storms, and during those high waves and turbulent times, our relationships and negotiation skills are essential. And these are occasions when injustice rears its ugly head and the attorney has to deal with it tactfully yet swiftly in order to properly represent his client. These are my disclaimers. These are suggestions and situations that I encountered in my own practice. They are for informational purposes only. If there is a problem with the court, and if there is a matter that cannot be addressed in court, I would advise an attorney to speak to the judge in a non-threatening forum, to explain his concern and explain his course of action, his own recourse. If there is no satisfaction, to follow through with that recourse. If it's an appeal, if it's reporting, whatever is necessary, but give the judge an opportunity to respond to the allegation. One of the allegations that I've seen in jurisdictions, especially because of the relationships that the attorneys want to maintain with the court, they will say in hush-hush tones stories like the ones that Judge Brown explained about the judge who turns his back. You hear stories in the hallways that maybe a judge only favors a certain type of person, or a judge will not respect a certain attorney. And those things need to be confronted. They need to be confronted. They need to leave the hushed tones of the hallway and be confronted so that the judge understands that we are all accountable in our practices. That is not to say that we don't honor the court or honor the legal process, but we use the legal process to gain successful outcomes for our client and to make sure that we individually confront injustice. The agency. The attorney's goal is to get the desired result for the client. It is the attorney's responsibility to learn the agency protocol, to determine what the policies are, how they compare to law, and then work his way up the system to begin with the case manager. The case manager has a supervisor. Then the supervisor has a supervisor. If you have to go up to state office, it is advised that you do so. But there are ways to handle situations, and if that fails, to object on the record in court for the injustice that has been done to the client. Provided that the service or whatever you are requesting has been denied. If there is a failure to follow case plan goals, permanency plans, the code provides an avenue for sanctions if that's absolutely necessary. These are tips for case reviews, and these are for our OCS staff. Our number one problem in the jurisdiction where I am are timely case plans and court reports. The law provides that those court reports have to be filed 10 days before that court hearing. That allows for all the parties to object timely to any adverse recommendation in the case plan. What happens when you don't get them in on time? That's a cause for a continuance. And in many cases, I use that opportunity to ask for a continuance in order to state my own written objections. Also, it is a delay, a gain in the life of the child. There's no reason for continuous late court reports and case plans. Also, updated information in each court report and client contact. To maintain regular contact with clients is so important. Also, receiving updated information. It is an injustice to the family when the court report says one thing and then we get information that that report is stale, that there is more recent information. The case manager should know that case better than any other person. It is that case manager's case. And we expect when we receive a report that that report is up to date. If it is filed prior to information, send a court letter to the court and just update them. Little Johnny's on runaway and has not been located since this date. We have had to change a placement for little Jill, but update the court accordingly. Promoting progress. It is the attorney's responsibility to promote the positive aspects of the client's progress, and in addition, the case managers do too in their reports. It's only fair. Although it may not support the ultimate recommendation of the agency, it's only right and fair and truthful to say that the client did what the agency asked him to do. And lastly, again, consider the court's point of view. They are handling a life, and it's important for them to have all of the information on the table as they make recommendations regarding a child. Advocate for your client. Zealously advocate for your client. I did not go into the different styles of examination and cross-examination. Those are things that each attorney has to develop on his own according to their own personality. However, to advocate for your client not only speaks to the client's well-being, but speaks to the responsibility that we have as advocates to uncover every legal argument for a client is absolutely necessary, and that includes representing the agency, uncovering every legal argument that you can to represent your client. Also, and I'm going to have to end as I'm wrapping this up, to identify area professionals and service providers. If insist that your clients receive services in a timely manner. That means referrals go out quickly. Check references of service providers. If a service provider, let's say it's a psychologist, provides reports that are always negative about every client, then it's time to ask for another provider. If the provider doesn't provide hope and doesn't provide avenues for that client to overcome his own barriers, it's time to look for another provider. If their own perceptions and their own experiences bars them from publishing a fair report, then it's time to change. And I'm going to end with transitions. Because of the changes in the YAP program, and I know all of you are familiar with the changes for YAP, our judges are now requiring us to do all of the transitional planning early, so that it's not done at the very last hearing before the child ages out. It's necessary to begin those transitional plans early. That includes educational plans, what's necessary for that child to progress to the next level, independent living training, living plans, where is that child going to go when he leaves foster care, vocational training, mental health management, who is going to handle this child's management of medications and assessments once that child leaves care. Make sure the child has a driver's education. In some cases, licenses, birth certificates, social security cards, visitation resources and support systems. To assure that this child can transition and the judge can make that decision confidently, feeling that this child is, if not prepared, then is prepared as they can be when they leave foster care. I'm sorry I didn't get to complete the, oh, okay, good. I didn't get to complete the presentation. However, I just found out I had a few more minutes. Serving parents and children with disabilities. This particular issue is very close to my heart because there is a strong presumption with clients who have disabilities that when the children come into care, that these parents will not be able to parent because of the obstacle that their disability provides. It's important to give the services, to not presume that they won't be able to, but to have measurable means by which we can determine the client's limitations and strengths. If there are none, that is a bar to termination. And as an attorney, I would make sure that that is the case. If a child comes into care from the hospital after being born, and we have really no grounds for needed care except for our strong suspicions that this parent might not be able to, then we need to have permanent goals that allow the parent to go as far as they can go within their own abilities. And that means providing those services also in a timely manner to determine what it is that parent needs to do. And if the parent cannot perform, then at least we have the knowledge and we have an objective means by which decisions can be made. However, to deny the parent the opportunity to have services, parenting training, having training with nurses to learn how to care for a special needs child, to not build a support system for that parent is, I don't have words to explain it. I do know that although mental health is not a grounds for termination now, it can certainly delay the process, even if the grounds are termination, and even if you have a waiting parent who wants to adopt the child. Make sure, and this is really in your best interest as a CASA, it's in your best interest as a case manager or a CPI, well, CPI is not involved at that particular point, but as an attorney, to make sure that we have explored everything on behalf of that client. I want to thank you all for your attention. If you need to contact me, this is my office number, and I'm located in Baton Rouge. This is my email address. I would be happy to answer any questions for you. We are willing and happy to answer any questions that you might have. We want to see you be successful in your own individual practices, whether that be law or whether you are a CASA volunteer or supervisor, whether you are a case manager or adoptions worker or a judge. We want to make sure that if there's anything that we can do, we want to make our services available to you. Are there any questions at this particular point? Yes.
Well, Merry Christmas again. I wish you well for the holidays, and I'm just thrilled that we're moving towards the holiday. It's been a rough fall. We've had a lot of work to do in the courts, and this program has been very challenging to me. I'm invigorated, encouraged, and most of all challenged to learn about those areas that I still have to study and to be prepared for. But the subject matter that we've tackled today has been something that we have been remiss about for a very long time. Hopefully today, for me personally, it pushes me further down that road, challenging my abilities as a judge. Although you've heard my name a couple of times today, it's not a perfect court. I believe we have a lot of work to do. I'm just fortunate that I have competent attorneys that challenge things and don't accept the status quo, that we have caseworkers and supervisors who are willing to stretch themselves intellectually, stretch the the workday and to advocate and provide for children, even in the worst of circumstances and always in the worst of budget circumstances. I hope that you share the challenge to continue this work. And again, happy holidays. Before we end, I'd certainly like to give Mr. Mark Harris an opportunity to make any last words that he would like to make in terms of this important court improvement project. I think he was telling me that this is going to be recorded and will be available to you on the website. Which website, Mark? Because I'm certainly interested in getting this information.
It'll be available on our child welfare, multidisciplinary child welfare website, the CLARO website. That is the acronym for Children's Law Advocacy Resource Online. That's www.clarola.org. It's www.clarola.org. And there are several other programs on there for online CLE credit, and we are developing it and have been developing it for a couple of years as a clearinghouse for child welfare practice information across disciplines, and I encourage you to go there and scoot around and take a look. We'll have this program posted there when we get the DVDs back from the videographer. We'll also post all of the handout materials, and I'm hoping that you will go there frequently and become a part of that process, make suggestions about things you would like to see there. If you have resources that you would like to post there, you can email them to me, and I will get them to the web administrator for posting in the appropriate category. In closing, I'd like to thank everyone for coming. This was a great program today on a topic of serious consequence and importance to all of us. I'm hoping that you will take this information back and not just sit on it in your own mind, but help to push it out into your organization and into your work and into the lives of the families you touch. And so with that, I bid you goodbye, and I hope you have a safe trip home. Thanks.
See you next year.